Good afternoon. This is Attorney Elise Gross. I've been an attorney for 20 years in South Florida. My practice focuses on estate planning and asset protection. I am also an adjunct professor at Florida Atlantic University, where I teach wills, trusts, and estates. After the webinar, if you're interested in additional information about estate planning or asset protection, we do speaking engagements, have a monthly newsletter, and give complimentary preliminary consultations. If you're interested, please contact the office. Feel free to send your questions during the webinar to info@assetprotectionattorneys.com. We will have a Q&A period at the end of the webinar, and we'll try to get to all your questions. We're going to type in the call number that you see on the screen into the chat box for anyone who entered late or gets disconnected. An overview of today's presentation. Today we're going to cover what estate planning encompasses, why everyone should have an estate plan, an overview of the estate planning tools to use during your lifetime and at death, everything you need to know about incapacity planning, when you should use an irrevocable versus a revocable trust, an overview of the probate process, how estate planning works with asset protection, and when it's appropriate to review your estate plan. We can define estate planning as the managing and passing of your assets through the preparation of documents and retitling of those assets. I personally like to call the process integrated estate planning because asset protection and estate planning work together to form a comprehensive plan. Having one without the other would be incomplete. Everyone should have an estate plan so that they can control who gets their assets, how and when they get them, and who controls and manages the assets that are passed. In addition, the estate plan covers an individual should he or she become incapacitated. Estate planning documents can be broken down into three categories: incapacity planning documents, wills, and trusts. Out of all the three categories, wills is the only category that applies at a person's death. Incapacity documents are for a person's life and can be used during life and after a person's death. First, I'd like to go through the types of documents that you might have for incapacity. The first one is the durable power of attorney, which is a document that names a person who we also call the agent to handle financial matters for you. Some states allow you to have what's called a springing durable power of attorney that kicks in only in the event that a physician signs off on your incapacity. However, Florida recently changed its law and doesn't allow the springing powers. The net effect of that is that you have to be very careful whom you choose as your agent, because the person's power is effective immediately upon signing the document. So with that in mind, a good Florida attorney will show you how to avoid the potential for abuse that this law might allow. Despite this, it's important to have one of these documents, as it may assist you to avoid the need for a guardianship in the event of your incapacity, because the durable nature of the power of attorney, that's why it's called a durable power of attorney, allows it to survive your incapacity and still be effective. Guardianships, on the other hand, will strip you of your rights and can be very costly to your estate. The next document we'll discuss is the healthcare surrogate. The healthcare surrogate is like a power of attorney, and it gives your surrogate the ability to make your healthcare decisions for you, but only if you're unable to make those decisions yourself. The springing power in the healthcare surrogate hasn't been invalidated under Florida law. Next, we have the declaration of pre-need guardian. I like to use this as a just-in-case form. It allows you to name your guardian in case there's no choice but to have a guardian appointed for you, which sometimes can't be avoided. Next, we have the living will, and the living will lets you inform your family and medical team that you do not wish for life-prolonging procedures to be administered to you in the event of certain conditions like a chronic vegetative state. It's important to evaluate your religious beliefs before executing the living will, as there can be conflicts. In addition, it's important that the person you name as your healthcare surrogate be aware of your wishes so that the healthcare surrogate doesn't override your choices. Lastly, I wanted to talk about joint tenancy that's used in estate planning. There are ways of titling assets so that you can immediately pass them at your death without going through the court, such as joint ownership with rights of survivorship or designating beneficiaries. While survivorship ownership does pass at death without court interference, it has potential creditor issues and gift and estate tax issues. If you want to use this, you should consult your estate planning attorney. Designated beneficiaries can also be helpful, but again, as you will see when we discuss trusts, you may not accomplish your ultimate goals by simply naming a payable on death beneficiary. Wills are also known as last wills and testaments. This is a document that allows you to name your beneficiaries, your personal representatives, and the guardians of your minor children. A will is an essential to go, but they will have to be administered by a probate or surrogate's court to get there. A will disposes of any property that's owned by an individual at death, for which there's no survivorship provision or a living designated beneficiary. In a minute, we will discuss how you can minimize the assets that go through your will, but I'll reiterate that you should always have a will just in case. If you have no will and no trust, then state law determines how your assets will pass, and that will probably not be the way you would have wanted. So it's important, no matter what, to at least minimally have a will. In addition, if you don't have a will, or if you have a will and a minor child is set as a beneficiary, there may be a requirement for the minor to have a guardianship set up for him or her in order to hold the money. In your will, you'll name guardians for your minor children. And there are two types of guardians. First, we have guardian of the person, and then guardian of the property. The guardian of the person is the person who will have physical care and custody of your minor children. They'll be the ultimate caregivers. The guardian of the property has the court-supervised control over the child's money or assets. For instance, an inheritance that they may get from your estate or from a grandparent's estate. These guardians do not need to be the same person, but it does make it easier if they are. You would want to have separate guardians if you feel that you have a relative or friend who would do an outstanding job raising your kids, but they're not very good with money. As a matter of course, you should know that states have different rules on who can be a guardian. For instance, in Florida, you can only name a relative who lives anywhere or a friend who's a resident of Florida. Next, we're going to talk about trusts and their use in estate planning. Trusts can be a very useful tool in estate planning. There's no monetary threshold for who should have a trust. It depends upon your goals and your family situation. For instance, I had a client who was single, widowed, no children. He had about $2 million, but he didn't want the added complication of having a trust. So he used a will combined with some payable on death provisions to accomplish his goals. However, when I have a client with young children, with a second marriage, or even an older person in poor health, it's important that I have a lengthy conversation with them about the benefits of a trust. A trust is a document, and it allows you, as the grantor or the settlor, to designate beneficiaries of the trust and to name the trustee to manage the trust assets. The advantage to a trust is that you can have a trustee monitor when a beneficiary receives money, rather than give the beneficiary the money outright at age 18, which is the legal age for a person to inherit. There are many types of trusts, and they fall into two basic categories: revocable and irrevocable. A revocable is the most common trust and is also known as a living trust. This type of trust lets you avoid probate and helps you avoid a potential guardianship in the event of your own incapacity. You can be the trustee and the beneficiary until you die, and then the document will dictate how, when, and under what circumstances your beneficiaries get your money. If it's properly drafted, it can hold almost any asset and can protect the beneficiaries, other than yourself, from creditors taking their interest. The trust is revocable until you die, and then it becomes irrevocable. The revocable trust should not be used as an asset protection tool and doesn't avoid estate tax, although it can help minimize estate taxes. If you have a revocable trust, you would also execute what's called a pour-over will, so that any asset that you didn't transfer into your trust before you die will pour into the trust at your death. In contrast, we have the irrevocable trust, and that's a trust that you cannot generally benefit from yourself, and you cannot be the trustee. Therefore, you're giving up control. This type of trust is used for asset protection, charitable gifting, and tax planning. The most common use of this type of trust in estate planning is to hold life insurance. Most people don't realize that the death benefit of life insurance is included in your taxable estate when you die. Therefore, if you have a $2 million life insurance policy payable on your death, then your estate is valued at $2 million plus whatever else you owned. If you have a special life insurance trust and you follow all the IRS rules, then the $2 million can pass to your beneficiaries in full without estate or income tax. You can have a revocable trust and no irrevocable trust, but if you're doing proper estate planning, you probably wouldn't have the irrevocable trust without the revocable living trust. Let's talk about the probate process. The probate process is the court process that's needed to pass assets that are owned by an individual to the beneficiary after the owner dies. We've already discussed that designated beneficiaries, joint owners with rights of survivorship, and trusts can avoid this process, but now we'll talk about why you'd actually want to avoid it. The court process can be lengthy and expensive. It also opens up your life to the court. While many of the documents are not necessarily made public, they are part of your court file to be seen by judges, clerks, family members, and anyone else who finds a way to gain access. Trusts don't fall into the category, therefore they avoid probate. The probate process involves a person being appointed by the courts as the personal representative, or executor as it's called in other states. The person has to hire an attorney for the estate and go through all of your stuff to get an inventory. They have to then wait a minimum period of time for creditors to come forward and make claims against your estate, and then, if you're lucky and all goes well, the assets can be distributed. Unfortunately, I've rarely seen a case that goes through without issue. The shortest formal estate, as opposed to a summary administration, that I've ever done was 5 months from the time it was submitted, and it was a simple one. 1 beneficiary and 2 small creditor claims. The longest ones have been going on for years, even though they have no money. But if there's any complication, it takes time to address it. The best plan is usually to try to avoid probate. But whether a person has a will or doesn't have a will, if they do own anything in their individual name, not in a trust, no designated beneficiary or a survivorship provision, then probate's going to take place. So that's why it's imperative that you choose your personal representative and alternates carefully, and that you keep your papers in good order. The more work that needs to be done after your death, the more time it'll take and the more costly it'll be. Finally, the individual assets that pass to those beneficiaries who are under 18, as we discussed before, are going to require a court guardianship of the property. When that child reaches 18, the guardianship automatically ends, and the children take the money at 18 and are generally spending it within a few weeks, few months, few years, but fairly quickly, as 18-year-olds are not notoriously responsible with money. Let's talk about how asset protection works with estate planning. Asset protection is the legal process of titling your assets to get them beyond the reach of future potential creditors, whereas estate planning may also involve retitling your assets to keep them out of probate. The key is to know how to combine the goals so that the probate is avoided, creditors can't reach the assets, and the asset protection plan extends beyond your death for the benefit of your beneficiaries. I've given you only a brief overview of the estate planning process, but I hope that it will encourage you to either create an estate plan or have your current plan reviewed. Existing plans should be reviewed if you've gotten married, divorced, lost a primary beneficiary, had a serious falling out with an existing beneficiary, had a major change in your financial position, or if you've moved to another state. A good estate planning attorney will plan for as much as possible in your documents, but it never hurts to have them looked at every once in a while, as laws may change that can affect your current plan.